running. Same cast of characters, right? Smile.
Good afternoon. Is there anything we could, well, first, actually, before I get into that, I apologize for my voice, dealing with a cold, and I'll try not to infect anybody except the people near me. We should be on this is the part where it's annoying, the voice is shot, and you feel fine, but, you know, what can you, other than that, you know, hacking, so. Anything we need to do before we get on the record? Cool.
Could we request that you folks use a microphone so that we can all hear well, please?
Okay. Let's see if it works. The lights are on. They produce feedback, which is the concern. Well, I'll do the best I can about speaking up, but we have a little problem right now. Okay. Right now. Why don't we get started? Good afternoon. This is a status conference in docket number 8653, investigation into sound levels from the Vermont wind electric generation facility in Sheffield, Vermont. The board has appointed me, George Young, to be hearing officer in this proceeding, assisting me are Vin Fabrizio and Kevin Fink. And why don't we start by taking appearances, please?
Aaron Kasicki on behalf of the Department of Public Service.
Denise Anderson on behalf of Paul Brouha.
Andy Rodvogel and excuse me, Jeff Hand for Vermont Wind LLC.
Great, thank you. The purpose today, and we'd originally tried to do this by phone, and then because of other things, everybody, we hear back from the parties that you prefer to be in person, so here we are. My view is what we're trying to do today is set a schedule for moving forward. We've seen all of the three different filings, and it appears that despite everybody's best efforts, you weren't able to reach a settlement, and or should I say a consensus around a wind monitoring plan. So we need to set a schedule for a resolution. And I do know that the Sheffield Wind has provided one. I didn't see other schedules provided by other parties. I don't know anybody's reactions. So is there any, well, having stated that that's what I view the purpose of today's proceeding, is there something else we need to be taking up?
We don't think so. That we agree the schedule should be established. And if I may, I can say a word or two about the schedule we proposed. We work backwards. I think all the parties are in agreement. I'll let them speak for themselves. That we want the monitoring to occur at the next available time. That would be, and to start no later than April 1st. We had sufficient discussions to know that there was, I think, general agreement around that date, give or take. So I worked backwards and simply tried to develop a schedule to accommodate having somebody out in the field as of that date. Parties engaged in a number of conversations about the monitoring plan. We are intending to continue some of those discussions, but in the meantime, we felt the need to get a litigation schedule on the books and moving forward. This is the briefest of litigation schedules we could come up with, given the time constraints, given the holidays, given the April 1st deadline that we're trying to work towards. And so I think the individual items speak for themselves in terms of pre-filed technical hearings with live rebuttal and then briefing. The one thing I'll note is rather than taking what could be too much time for discovery, formal discovery, we have simply included with the pre-filing testimony the requirement that parties disclose documents reviewed and relied upon by experts, similar to a federal case disclosure, and that would, in a sense, be in lieu of discovery, or be in lieu of other steps of discovery.
I assume the other parties have had a chance to see the proposed schedule. Any reaction to it? I'll start with Mr. Brouha.
Thank you. I have not seen it before, and perhaps I missed it somewhere in the snow and everything else. I don't have any problem with it, except that I'm going to be out of the country through January 8th. So I would want to push that back a couple of days. But the other dates, if we can keep the other dates, that's fine with me. So if we could move the proposed date on January 9th to later in the week. That would be my request.
So the January 9th is a Monday. Would you be looking for the 12th, 13th? That's the Thursday and Friday.
I'd prefer the 13th, but at least the 12th or 13th, depending on how constrained that's going to make you and others.
Well, if we keep the hearings where they are, it's not going to change. The constraints on us don't change. We keep the hearing dates on one of the three dates proposed here, the 19th, 23rd, or 24th.
I'd prefer the 13th then for the pre-filed testimony.
Mr. Kosecki.
We have seen the schedule, and we agree with it. The one thing that has been put on my radar since initially looking at it is that I won't be available on the 24th for technical hearing.
Okay.
Otherwise, the schedule looks fine. The department, I would also add that I've run this proposed schedule past our expert, who noted that while this schedule contemplates having monitoring to commence by April 1st, he's noted that ideally we would have monitoring commence by March 15th. He thinks that 2 weeks in March is a fairly ideal time to get the kinds of conditions, or have a greater likelihood of getting the conditions that we're looking for.
Okay. So would the period between the 13th and the 19th be too tight? So should we do the 13th and the 23rd? I don't know what each of you thinks you need to see from the other parties and how much review time you think you need as an incremental step in between. I mean, from our standpoint, we need time to read it, that's about it.
Right. We were going to suggest if we shift the pre-file to the 13th, that the hearing date either be the 23rd, 24th is not available any longer. If the 23rd didn't work, to see whether the parties could do the 25th. We're good on the 23rd.
13th and 23rd works for me.
What dates are we talking about for hearing?
The 23rd of January.
Okay, not the 19th?
I think
I have an active meeting during that day.
The 23rd?
Do the parties feel like we were likely to need the entire day, or?
It's at least three witnesses. I would think we should schedule the day just in case. It sounds like, is there a problem on the 23rd?
I have an active 50 hearing on the
Les
23rd.
Mr. Blomberg has a previous engagement on the 23rd, so we could do the 24th. That was unavailable there. Okay.
So 19th or 25th, I don't care one way or the other, I guess.
And I'm unavailable on the 19th, I'm sorry about that. I
Oh,
didn't see
okay.
that previously, yep. So,
we go.
there you go.
Got 'em all.
Between all of us, three experts, yeah.
13th for testimony, 25th for hearing.
That works.
Anybody have any problem with that?
We'll just need to confirm with our experts, since I don't think we checked on that date.
Yeah, I'll have to check with my expert as well, but what's this stuff?
Now, the next item I want to take up on the schedule is, you're referring to a hearing officer order remonitoring. Just in terms of process, are you looking for, I mean, from our standpoint, it would be, if this is sort of final disposition, I don't actually have the authority to issue an order. The board has to issue the order. I can issue a proposal for decision. I can issue some kind of interim procedural order, recommend, on the monitoring plan. I'm being cognizant of not wanting to go beyond the scope of my authority in making final disposition of the matter. It's not clear to me what final disposition is in the context, since it really is determining whether there is a violation, and perhaps I have the authority to issue an interim order. Are parties comfortable with basically me signing an order that my coworkers are going to write for me, that lays out the parameters? I mean, because there is the right to challenge any decision ruling I have made to the board. So,
I agree that is an issue, and if it were a final order by the board, it doesn't seem like there's enough time. It would be difficult, especially if we move the target commencement date to March 15th. That really makes it tight. We did assume that, as hearing officers often do, that you can issue interim orders. Given the scope of the docket, I think you're correct that there's going to have to be a final order by the board on the ultimate question at hand, as to compliance with the CPG, and all parties would have an opportunity to be heard prior to that final order.
well, I don't need a final decision necessarily today, but I want everybody to be aware of that, because I don't want to get everybody geared up for a particular process here and then get an objection on March 1st saying, you can't do that. We want one oral argument before the board that blows up the entire process. And if parties want the right to challenge whatever I order or recommend to the board, then we need to know that now, because that basically means we need to turn something around like immediately. I can set up a time period where everybody can tell me how they feel about that. I just want, I don't want to be in the position of finding out after I issue whatever I issue that somebody immediately wants to challenge it to the board, because at that point we should have set up some different process.
The difficulty, we agree in principle. I think problem would become that if you issued an order that was potentially so at variance with the expectations of a party, and it's an order that they would reserve the right to seek a motion for reconsideration of that order, or to be heard by the board, so it would be different than you're issuing a proposal for decision, which would have that automatic comment period and then oral argument. This would be an order which would then have the procedural opportunities that any order would have.
Well, we have one pending, which I apologize for us not actually having finally acted upon. There apparently too many people involved in it meant that everybody thought it was in a different location than where it was, and we'll get that sorted out and resolved. I just wanted to raise it because I don't want to issue something and then immediately have the entire process be derailed get spring monitoring. Which I don't think is in anybody's interest, but I don't want to deprive anybody of their procedural rights either.
I would just note, I'm comfortable with the hearing officer issuing an order and the parties acting on that order as opposed to intervening approach. I think that's consistent with the order that's already come out in this proceeding that has ordered additional monitoring. The second issue is, I think all the parties here agree that we want to get monitoring started, so we're all on notice that we should try to get something to you that as close as possible, if we can all agree with. And I think we've made a lot of strides between the three parties to come up with a protocol. I mean, we're in a lot of agreement on a lot of issues that we were certainly not on the same page about outside of these discussions, so.
So,
It's interesting, you've been quiet through this latter part of the discussion, so I'm going to put you in the spot now.
And I think I should probably have an opportunity to talk to Mr. Brouha, but I have to agree with Mr. Kasicki in that we want to do whatever we can to ensure that we're going to start the monitoring in mid-March. And it sounds like a proposal for decision is the way to do that. But I do think I should visit with Mr. Brouha before I take one position or another.
Let me just say, if you're aiming for mid-March, I think the proposal for decision is going to be very hard to get accomplished by then, because we have to issue a proposal for decision, give everybody a chance for comments, and then the board has to deliberate on the ultimate order after that. That it adds an extra step of, a minimum of 2 weeks, but it preserves everybody's procedural rights. That's why I'm raising the issue.
As opposed to an interim order.
An interim
yes,
order. Go ahead.
no, Which wouldn't have a formal comment period.
But it would open it up to a motion for reconsideration.
To the board, and whether that stays the effect,
Right.
presumably it would stay the effectiveness. So you end up in the same place. I simply wanted to, again, I don't want to take anybody's procedural rights away. This is one where one could argue what I'm doing is final disposition in certain ways, and one could argue that it is an interim procedural order since it's specifying a monitoring plan, but nobody's going to want to go back and do monitoring a second time, so that's why I'm raising the issue in terms of where people want to be on this. So people can get back to us within a week so that we know what we're doing. But I did want to raise the procedural question though. Let me throw out one more. Please, in the pre-file testimony, identify the issues that you're asking for resolution of. I've read all three of the filings, and you all approached it. There are areas where I can tell you agree, and areas where I can tell you disagree. And there are areas where everybody phrased it differently, and I'm not sure how much there's agreement and disagreement. And I don't want to be in the position of the last time where, gee, I thought I was deciding 4 questions, and then I got proposed other questions, and I want to know what you all want me to decide and what we don't need to decide, and be really clear in the testimony, because as I said, there's lots of parallel language here that I don't know whether, when I'm looking at the department's discussion of unweighted 1/3 octave spectra, it's the same as what Sheffield Wind is saying, and the same as what Mr. Brouha or Mr. Blomberg in this, probably in this case,
Right.
is saying. And help me out, because I will freely acknowledge I am not a sound engineer, nor do I ever want to be one.
Neither do we.
Well, yeah, I know, but you guys have to provide the
I
help,
know.
because I do not want to be deciding things I don't have to, and I don't want to be deciding the wrong things.
Fair enough. I actually think we have a decent head start on that, just from the discussions we've had. We've been working off of a a similar outline, so.
I assume so. It's just, I started putting the three in parallel and thinking, oh, they've been talking about it, they all will have the same outline. And then I discovered after the first couple paragraphs, oh no, you did it differently. Now I had to figure out how I'm comparing all of these. And
Because nobody used the outline for that.
right. Well, your job is to assume that I don't know anything and make it easy.
And we don't use the outline, we just improved upon the outline.
Which helped immensely. Okay, anything further from anybody else?
The one last thing I would say, just very quickly, is I just want to make it clear that my expert's suggestion that we try to shoot for a March 15th date is purely aspirational. It's not, I'm not saying that it's critical for the start time of March 15th.
Let me just say, I'm not going to commit to any particular date at this point. However, this has been going on for a while. There have been issues out there for a while. I will work with the chairman in terms of making sure that we can make this a high enough priority, because I think it's in everybody's best interest to get this moving. And so we will do what we can on our side. That's why I'm asking you to help me make sure we can do it, that, you know, we can focus on what we need to do to resolve this and get it done. If nothing further, we are